Well, welcome everyone to Steve Savant's Money, the name of the game. I'm your host, Steve Savant, syndicated financial columnist and funny color commentator. On today's show, the need for directors and officers liability insurance. Part 4 of our series on asset protection strategies for businesses with Ike Devji, protection specialist and attorney. Welcome to the fourth segment. Ike, I'm looking at this. We're in a whole new scene now. If you've been watching our segments here in succession, I kind of think this one was, at first, we talked about this years ago on the show, it didn't seem as bad as I thought it was going to be, but then it turned out to be almost as worse. Everybody says, I've just elevated you to the board of directors. And you're like, wow, I've just had a career milestone. You go home and tell your wife you're celebrating it, or you become an officer of the corporation. It seems so celebratory. It seems so, like I said, something you would celebrate as a part of your career. But then comes the exposure and liability. Tell me why we have it and what are the options here for us, and then we'll get in a little later on in the segment, I'll get into, I just wanted to help the nonprofit out by sitting on their board. Well, we'll talk about that in a second as well. Sure. So let's go first, D&O.
Great topic, important issue for every business owner. D&O is the way that's generally referred to, the shorthand for directors and officers insurance, as you said. And it is, I think, one of the most commonly overlooked areas of liability insurance by both business owners and by executives and people who serve, as you alluded to, on charitable boards or foundation boards or other things, philanthropic institutions. Let's start with how it perhaps speaks directly to business owners. And business owners typically, as you and I have discussed, think of their insurance as a policy. I have a policy. I have a general liability policy, right? So if you come into my building, if you come into my business and you slip on the wet floor and you have a slip and fall accident, I have insurance for that. If I have a truck that goes out with my company name on it and that truck gets into an accident, we have general liability insurance for that, right? In addition to those kind of slip and fall accident general liability claims, we may also have E&O or some kind of malpractice insurance, right? For the service that we're delivering. And for most business owners, that's where their thinking ends, right? I got a slip and fall policy, I got a malpractice policy, I'm done. Unfortunately, there are a lot of exposures that every business owner in America faces, whether they know it or not, and are legally responsible for, whether they've actually ever articulated that to themselves or with an advisor or not, that they're not thinking of. So for instance, let's think about a doctor. He thinks that he's got really two sources of exposure, but the only one he ever thinks about is malpractice. He maybe sometimes thinks, well, let's make sure the floor isn't wet so nobody falls down. But between those two, he thinks he's covered. But he also owns a business like every other business in America that has regulatory compliance issues, that has a tax return that somebody is responsible for filing, that has employment policies that have to comply with federal and local law, right? All of those other regular business owner activities, those executive responsibilities, are always linked to an individual person. And that's where the D&O often comes in. And that exposure might not just be from the outside, it could easily be from a partner, an investor, or another business owner as well.
Did I just hear you say the ultimate expression of any entity that's organized is the person who's on the board or owns it?
Well, somebody always is ultimately responsible. A person is ultimately responsible, right? I mean, we've seen, even with massive corporations, we saw a landmark case out of California a couple years ago where a CEO was of a major multinational corporation based in California was hit for a $150 million judgment for being personally liable for labor violations. Right? So when these systemic things happen, somebody is accountable.
Yeah, not an entity, a person.
Yeah. The business, the person who ran that business, who approved that policy, who signed off on those things, can't just say, well, it's the business, it's not me, right? Either you were responsible for that or not. So
let's just stop there for a second, because this is just a little organizational law here, just as an insert. I got an LLC. You know, isn't that my defense? Don't I have a defense there? I have a C corp. You know, you're looking. People actually in the LLC example is probably the better one.
Right.
I thought the whole term was limited liability. I limited my liability because I put this entity between me and the public, but maybe not.
I think that yes and no is the best answer to that, right? And sometimes in the law there aren't absolute answers. Yes, you absolutely. Let me answer this the simplest way. Sole proprietor doing your business in your own name, almost always the worst choice in terms of limiting your liability and protecting yourself. That said, an LLC, as one example, can be a great tool. But to assume that just because you have an LLC means that you can't ever be found personally liable for anything is certainly ignorant folly. I mean, it's going to get you in trouble. Especially the more closely held or managed any business is, the shorter the food chain is in terms of who's going, how liability and responsibility is spread. So the more closely held and managed a business is, the more likely that those owners and managers are also going to be personally in that shadow of liability for what they do or what they don't do. Remember, it's acts and omissions. Failures, sometimes it's overt, and sometimes it's a failure.
In your experience, and I know this is a general question, and I'm not going to hold your feet to the fire for a stat, but more errors or more omissions?
I think it depends on the type of claim. Mostly what we see is something affirmative, where somebody agreed to, signed off, things like that. But there are certain kinds of claims where failing to act is often the source of liability. For instance, allowing a discriminatory hiring procedure that you know has been in place for a long time and doesn't make any sense. Like, you know, Bob says, sure, bring them in, but make sure they're young and pretty, right? If you know that's how your business is running, you have a systemic problem there that I think is an omission at that point in not acting to correct it.
Yeah, I would say, I was just thinking of Hooters, you know, I'm sure they're recruiting based on the physiology of their waitresses. Right.
And I mean, and in Hooters and, you know, other places like that, I'm sure have some legal carve-outs and exceptions that they've looked at very carefully.
So I'm a director. Let's say I'm a director, or I'm an officer. Is this big money again? Are we talking another couple grand? Or
in most cases, it's a few $1,000s.
Which to me is totally reasonable. Why would you not do this?
Well, let's talk about what happens if you don't do it to put that cost in perspective. We had a client who came to us after being advised by a well-informed insurance advisor that they must have D&O insurance because they had a bunch of different businesses. In some of those businesses, they had solicited third-party investors. You and I have talked about that in the past and some of the things that in our discussions about risk factors. So that was one of the risk factors they had. And they were warned that this could protect them not only against claims from outsiders, but in case they got into a fight or a dispute with their business partners and investors. That may sound odd to people, but that was something that we saw every day during the recession. Right? Every business that went bad during the recession because of the rough economy, partners all started pointing fingers at each other and suing each other because they were scared and they wanted their money back. In this case, these folks passed on a policy that would have cost $2,500 a year. There was an intra-company dispute. Didn't even come from outside. Partners started fighting among each other and suing each other. The guy who passed up on the $2,500 policy spent $250,000 on legal fees out of pocket defending himself against those claims, and all of that would have been covered with that $2,500 policy. So does that put that value in perspective for you? Because it sure did for me.
Well, you just said I could totally see the multiple organizations that I'm involved in. There's stuff going on. I can't oversee that. I can't keep I can't monitor something at that size. I have to have protections against things that I don't even know about. I can't even foresee. We're short on time, but I want to volunteer for a charity. I'm going to sit on their board. Same exposures?
Absolutely. We routinely see people pulled into legal disputes for services on religious organizations, hospitals, philanthropic organizations of every kind. Look, I love that you want to serve that way. I serve that way with different organizations. We encourage that kind of service in any form that you have the ability to give, but you need to do it intelligently. And frankly, the higher net worth, the higher income you have, the more you have to lose. So if you're going to do that, it's vital that you get a copy of the in-force D&O policy that covers your service. Don't take their word for it, because we find when our clients check at our suggestion, the organization often discovers that that coverage either isn't in place any longer or isn't at an adequate dollar amount.
We need to protect ourselves. And again, I just exhort so many of us that are involved in voluntary. You are, I am. You know, we're down in organizations. We love our organizations. That's why we're participating. But we have to kind of cover ourselves. This is a personal liability. If it's the same for my business corporate life, I don't see it being any different than my nonprofit relationships. Don't forget to watch our next key segment, our key personnel coverage, part 5 of our series on asset protection strategies for business. And keep in mind, before moving forward with any of the ideas on our show, always check with your tax consultant, legal counsel, or your financial advisor. You've been watching Steve Savant's Money, the name of the game.